Okay, and then secret number 3, and this is the final secret in section 1, and perhaps most important, and one that we'll spend a little bit of time on, is entitled Prepare the Tone of the Examination. And when I first heard these ideas, which came from two doctors, actually, two independent doctors arrived at this procedure kind of simultaneously and independently. And when I heard these ideas for the first time, I thought that they were so powerful that I had to include them in this section. And this is entitled Prepare the Tone of the Examination. So you're now at the examination. Your injured worker is in the waiting room and you are ready to begin the evaluation procedure. So let's just first elaborate a little bit of philosophy of this section. And I want to talk a little bit about Labor Code 3202, which if you have your book of labor codes, you can look this up, or you can look this up online. This is known as the Liberal Construction Code. And if you look it up specifically, it says exactly that this involves liberal construction of Divisions 4 and 5. And I'll get into what Divisions 4 and 5 are in just a second. So Labor Code 3202 states, quote, this division, and it's referring to Division 4, meaning this division. Labor Code 3202 comes out of Division 4, so the code says this division, meaning Division 4, and Division 5, parenthesis, commencing with Section 6300, unparenthesis, shall be liberally construed by the courts with the purpose of extending their benefits for the protection of persons injured in the course of their employment. Let's read that again. This division shall be liberally construed by the courts with the purpose of extending their benefits for the protection of persons injured in the course of their employment. Now, you may not be familiar with this labor code or Divisions 4 and 5. But Division 4 includes labor codes 3200 through 6002. And this deals with workers' compensation and insurance. And most of the codes that we deal with come out of Division 4, as it includes labor codes 3200 all the way up to 6002. And Division 5 includes labor codes from 6300 all the way up through 7997. Deals with safety and employment. So think of it. That's a whole lot of labor codes, all the way from 3200 all the way up to 7997. That's the totality of Divisions 4 and Divisions 5. And some of the familiar codes that you might be familiar with in doing QME work include Labor Code 3600. That comes out of Chapter 3 of Division 4. That deals with conditions of compensation liability. Chapter 7 talks about medical examinations and includes the familiar labor codes 4060, 4061, and 4062. Those are the ones all involved with the QME panel process. Part 2 of Division 4 deals with computation of compensation. And anyway, I just list these codes here just to give you some examples that all of these codes are subject to the liberal construction instruction that were given by Labor Code Section 3202. In other words, all the labor codes involved with workers' compensation and the QME panel process and the rights of an injured worker to receive benefits and compensation all are subject to liberal construction. So what does that mean? Well, let's go back to the definition as it's described in section Labor Code 3202. It says that all of these codes shall be liberally construed by the courts with the purpose of extending their benefits for the protection of persons injured in the course of their employment. So what that means is, in the case of a doubt, in the case of a tie at first base, in the case of any gray area, all disputes are resolved in favor of the injured worker. All codes, all rules, all regulations, all procedures are to be liberally construed for the purpose of extending benefits to the injured worker. And so that's the tone of the examination that you want to adopt prior to seeing the injured worker. In fact, we're required to by Labor Code 3202. We're required to apply liberal construction to everything we do when that is appropriate and when that is necessary. So the tone of the examination, knowing the liberal construction instruction that we're given, the tone is established the moment you see the injured worker in the waiting room. You have an attitude of liberal construction the moment you meet the injured worker in the waiting room. And so let's talk about how we can establish with our injured worker a comfortable, relaxed tone that allows them to relax, to be comfortable, to be open and honest with us, and for them to not be defensive or offensive, which is many times the case in workers' compensation. These people are have sometimes gone through some rough times, and that's the last thing they need from us as the qualified medical evaluators. So we establish a tone of liberal construction early. And when we meet the injured worker in the waiting room, both he is observing you as much as you need to be observing him. Now, according to Webster's dictionary, the word observe means that we receive knowledge of the outside world through our senses. And when you first make your first observations of the injured worker, it makes sense, or it's common sense, to say that every detail counts. Well, similarly, your injured worker is examining and observing you, and every detail counts in establishing the proper tone for the examination. So you want to be caring, you want to be calm, you want to be kind, you want to be sincere. When you greet the claimant in the examining room or in the waiting room, you want to establish communication with a handshake and a smile. Remember that these are critical first moments, and just as you're sizing up your injured worker, they're sizing you up, and they're wondering if you are going to apply liberal construction to their case or not. Of course, they don't think of it in exactly those terms, but that's exactly what they're thinking. So be friendly, be caring, be kind. Meanwhile, be observant and gather information about the injured worker through their posture, through their activity level, through their station, and through their gait. Determine whether or not they're using any appliances or supports or assistive devices. When the examinee arrives in the examination room, make sure that all materials are set out in an organized and a visible fashion. This establishes a tone of organization and attention to detail. Have the chart available and organized. Have your instruments laid out in order, sequential with the examination. And think how your examination room appears to the injured worker. All of these details about the examination room are important in establishing an officious and a qualified tone. In other words, suggesting or indicating to the injured worker that you indeed are organized and you are qualified and you are the very best person to be involved in their case and their physical examination. Get the patient comfortable by taking their coat. Give them a place for their things and let them settle in. And I like to adopt a tone that I've learned from one of my colleagues, and that is to be like a butler, to be very service-oriented, not subservient, but service-oriented, and take care of them and make sure their needs are met. Remember, liberal construction requires that we orient ourselves and all our procedures towards extending benefits to the injured worker. And one of their benefits is to get service from you, the doctor, to make sure that they are treated kindly and fairly, and that they're comfortable, and that they're not embarrassed, and that they are relaxed. So be a little bit like a butler. They should feel like they're getting one of their benefits is by being served by you. Then, when you begin to speak with the injured worker for the first time, use caring, and kind words. You want to be official, and you want to establish that you are in control as the doctor. And the way you do that is by using caring and kind words. Kind words are powerful words. Albert Schweitzer said, "Constant kindness can accomplish much. As the sun makes ice melt, kindness causes misunderstanding, mistrust, and hostility to evaporate." Pascal said, "Kind words do not cost much, yet they accomplish much." Thoreau said, "The only way to tell the truth is to speak with kindness. Only the words of a loving man can be heard." And finally, Mark Twain said, "Kindness is the language which the deaf can hear and the blind can see." And that's what you want with your examinee. You want understanding, as Schweitzer said. You want trust, as Thoreau said. And you want comfort, as I said. And you want to use kind words, because kind words make it more likely that your examinee is going to be honest with you. And you can get down to the issues involved with the examination. Finally, you want to collect paperwork and review all the paperwork prior to beginning, the official beginning of the examination. Collect the paperwork, review for completion, signature, dates, etc. If there's any incomplete documents, make sure to provide those to the injured worker. Don't conclude that any missing documents are not necessary, because that makes it appear that they weren't necessary in the beginning when you first provided them. So follow through on any missing documents. Exchange driver's licenses with the injured worker. Provide the injured worker with your QME certificate. Allow them to satisfy themselves that you indeed are the doctor and you indeed are certified as a qualified medical evaluator. Confirm when you're looking at the injured worker's driver's license, confirm the height and weight with them compared to what it states on their driver's license. Many times there will be a disparity between what is indicated on the driver's license and what is the actual current height or weight in front of you. Compare address on the driver's license with what you have on your own demographics. And document the driver's license number in your report, which is another attention to detail. And once those sort of housekeeping administrative issues are out of the way, You're then ready to begin your opening procedures and remarks. And this is a brilliant procedure. And let's review where we are. We're discussing the tone of the examination, and we've established the tone in the waiting room with a kind handshake, a nice sincere smile. We've escorted them back to the room. We've taken their coats. We've gotten them comfortable. We've reviewed their paperwork and helped them with any questions they might have or any missing documents that they might have. And we're speaking to them in kind fashion. Then the very best doctors go through a procedure that involves the required disclosures that we are obligated or required to explain to the injured worker prior to their examination. And some doctors simply hand the injured workers a prepared statement. It's already written out on a one page and includes all the necessary disclosures that are required. Some doctors prefer to read this word for word to the injured worker. However you do it, you need to review these disclosures with the injured worker and make sure that they have complete understanding of their rights during this examination. And so I'll just give these to you in abbreviated form, and the entirety of these codes and regulations are included here in your handout materials. The first is contained in Labor Code 4062.3, and this involves sections E, F, G, and H. And you can look these up if you like. That's Labor Code 4062.3. Section E talks about all communications with an agreed medical evaluator or a qualified medical evaluator shall be in writing and shall be served on the opposing party 20 days in advance of the evaluation. Any subsequent communication with the medical evaluator shall be in writing and shall be served on the opposing party when sent to the medical evaluator. What does that mean? That means that after our examination today, if there's something that you forgot to tell me, or something that you want to tell me, or something that you think I need to know, I won't be able to take your phone call. If there's something you want me to know, you need to send it to me in writing with a copy to all parties. Make eye contact with them, make sure they understand this, and confirm their understanding and agreement. This is required that we explain this to injured workers in advance of the examination. Section F of Labor Code 4062.3 states that ex parte communication with an agreed medical evaluator or a qualified medical evaluator is prohibited. If a party communicates with the agreed medical evaluator or the qualified medical evaluator, the aggrieved party may elect to terminate the medical evaluation and seek a new evaluation from another qualified medical evaluator, or they may decide to proceed with the initial evaluation. Again, same point. Any communications beyond that which you exchange during the actual examination itself, any subsequent communications need to be in writing. And that also applies to you doctors. You are subject to the ex parte rules just as much as the injured worker. Make sure the injured worker understands that they are not to try to call you on the phone after the evaluation. Section G says that if you violate the ex parte communication rules, you'll be subject to being charged with contempt and could be liable for costs. Now that's usually an attention getter for injured workers, because they certainly don't want to be liable for any costs. So make sure that they understand that. Finally, Section H says that the above sections, sections E and F that is, shall not apply to oral or written communication in the course of the examination or at the request of the evaluator in connection with the evaluation. So basically this states that during the examination you have unrestricted communications, and you as the evaluator may be calling them up at other times if it's directly related to the evaluation, but under no circumstances the injured worker to contact the doctor except in writing. So get a head nod from them, make sure they understand that, ask them if they have any questions regarding any of those code subsections. If there are no questions with any of those code subsections, then you would go on to the next requirement, and that is contained in Title 8 CCR 40 Section A, which says the following, and we'll go through these carefully word for word. It says a QME shall advise an unrepresented worker prior to or at the time of the actual evaluation of the following. So when should this be done? It says prior to or at the time of. I do it both. I do it at the time of the actual evaluation, immediately prior to the actual evaluation. In other words, this is the final procedure to be done before you begin the actual evaluation. So it says we're supposed to advise the injured worker that, number one, he or she is entitled to ask the QME, and the QME shall promptly answer questions about any matter concerning the evaluation process in which the QME and the injured worker are involved. So they're allowed to ask questions at any time, and the QME is required to promptly answer those in a courteous, kind, caring way. Number two, that subject to Section 41G, also of Title 8 CCR 40, the injured worker may discontinue the evaluation based on good cause. Let's say that again. The injured worker may discontinue the evaluation based on good cause. Well, what's good cause? Good cause includes A, discriminatory conduct by the evaluator towards the worker based on race, sex, national origin, religion, or sexual preference. Or B, abusive, hostile, or rude behavior, including behavior that clearly demonstrates a bias against injured workers. And C, instances where the evaluator requests the worker to submit to an unnecessary exam or procedure. So the injured worker has the authority and has the right to discontinue the evaluation at any time if they can establish good cause. Thus, the importance of establishing a caring, kind, calm, service-oriented tone during the examination. You do not want the injured worker to discontinue the evaluation. So they need to be clearly apprised of this right, that they have the right, that if any time they don't feel comfortable, that if they feel that you're rude, abusive, hostile, mean, arrogant, you don't like injured workers, whatever, if they're not happy, they can discontinue the evaluation, and you do not want that to happen. You guard against that by using caring and kind words and being sincere. Section B of Code of Regulations 40 says that if you're, as a QME evaluator, if you're on probation with the Division of Workers' Comp Medical Unit, that you shall explain that to the injured worker, and they can ask you questions about any circumstances surrounding that, and this provides them an out also if they want to discontinue the evaluation. And then finally, and this is an important one, it says that if the injured worker declines to ask any questions relating to the evaluation and does not otherwise object on the grounds of good cause to the exam proceedings during the exam itself, the injured worker shall have no right to object to the QME evaluation based on a violation of this section. So what that means is if there is apparently no problem and the injured worker is comfortable with you and they don't object to any of your examination proceedings based on good cause, then they can't come back later and object, for example, after they've received the results of your report, for example. They can't then come back and say, you know, I didn't like that guy, I thought he was rude, I thought he was abusive, and I want to get a different evaluator. So they need to know that if they have a problem, if they're not comfortable, that they should state their objection and that they don't have to put up with that and that they can leave and they don't have to explain anything to anybody. So once you've gone over this thoroughly with them, and I mean thoroughly, make sure that they understand every point and that you get a head nod on every point, and make sure that they're with you, make sure that they're comfortable with you, make sure that they recognize that you recognize and that you know that they really have a lot of control during this evaluation, and if they want, they can pull the plug on it. They can pull the plug if they don't feel that you are in their camp. If they don't feel that you're applying liberal construction, and they might not know what liberal construction is, but they can feel your tone, and if they feel your tone is adverse, they can pull the plug and request a new evaluator. So they need to be made aware of their rights. So once you get a head nod on this, and you gain their understanding, and you've established the proper tone, then you're finally ready to finally begin the interview and examination. And that brings us to Section 2, Secrets of the Interview and the Physical Examination.